Hello, 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 everybody. Thank you so much for getting on. I know we start promptly. I'm letting some people dive in here with us so we can get started tonight. We are in for a treat. We're in for some good stuff to come. And I'm excited. I don't know about you. I'm excited because this is information that I've been wanting to know personally, information that I know is going to be useful for you. And it doesn't matter that you're still alive because it's necessary and you need to know and your loved ones need to know. This is important. And our guest who we have tonight, she came through about a year ago and taught us about the five legal documents that we needed. And those were awesome nuggets. So if you missed that, you need to go back and find it and watch it on top of watching this one over and over again. So tonight we have from the Jarvis law firm. Her name is Hope. And I am so glad that she is joining in with us tonight um, because she was our speaker last year. And so I feel connected to her. And so we're going to have a good time tonight and we are going to be educated and we're going to learn information that is vital for us and vital for our loved ones. So, without any further ado, I am going to add Hope on here with us and take the floor, Hope.
Thank you so much, Barbara. Again, thank you so much for having me on. I feel really honored that you asked me back. So I greatly appreciate it and really appreciate the opportunity to talk to all of you today. Hopefully, we've got some great information to share for you. So, um, just before I get started, a
Uh-oh.
little bit about me. And as Barbara said, my name is Hope Spangler. I work at Jarvis Law Office, and we are an elder law, asset protection, and estate planning firm. And that's really all we do. So, very focused on those specific areas and really helping families to protect themselves. And so, that's a lot of what we're going to talk about today. I know the initial information mentioned for today really focused on wills versus trusts and, which one might be better for you. And so we'll get into that in a second. Before we get into that, I wanted to let you know, because this is important, I am not an attorney. I work for a number of attorneys, and I've been with the law firm for the last 20 years. And I'm a certified dementia practitioner, Alzheimer's trainer, paralegal, and just know a whole lot of stuff from working in both the legal and the long-term care industry. So hopefully I can help you all navigate that kind of second half of life, which can throw some hurdles our way. So hopefully we can knock some of those down and make that path a little smoother and easier for everyone tonight. And so, Barbara, I don't know if we can share the screen. There we go. So I found an older presentation. So a couple of pieces in here are a little bit outdated, but I thought it would be a good template for what we're going to talk about this evening. And so it really is, with everything going on, all the changes that have happened over the last several years, we've got kind of new threats to our family security that we have to deal with, as well as some of the old ones that have, always been out there. And the thing that makes us a little bit different is we focus on not just estate planning, but specifically elder law. And estate planning really has to do with what happens to your stuff when you die. But elder law focuses on, well, what about all of the time leading up to the point in time that you pass? Or what if something happens and you can't take care of yourself and you need a little bit of help getting through the day at some point in the future? And that's what elder law encompasses, planning for what comes ahead as well as when someone passes away. And so, one of the things that we're going to talk about is, not necessarily understanding what some of those things might be, or not knowing how the law really works in ways that most of us are surprised by if you don't happen to work in this area in an everyday course of things. So, one of the first areas that most people are shocked to find out is that a will doesn't avoid probate. It's actually the instruction for probate. Most of us have heard at one time or another that we want to avoid probate, but not everybody knows why they want to avoid probate. And so most of us want to avoid probate because it takes a long time to go through that process. If you have less than about $40,000 in total assets and what you're leaving behind isn't going to your spouse, because there are shorter ways to get things over if you have a more modest estate, and an estate is just your stuff. Or if it's going to your spouse, then things can go a little bit more quickly. On average, though, if it's not going to your spouse, if it's going to your kids or other beneficiaries, and if you have more than $40,000 in total assets or your stuff, your house, and other things, in Ohio, the average length of time that it takes to go through that process, according to AARP, is about a year. Well, that seems like a really long time just to get your stuff to whom you've named in your will. But unfortunately, that's how the probate process works. Sometimes it can happen a little bit more quickly, maybe 8 to 12 months. But as a general rule of thumb, we tell people to expect at least 8 months and probably closer to 12. And that's because of the waiting periods built into the probate process, which is a slow process that goes through the probate court. Important documents, and Barbara alluded to this as she was mentioning the previous show we did together. Some of the other things that are really important for people to have are a financial or general durable power of attorney, a healthcare power of attorney, and a living will. Those are all good things. And then someone can also do a transfer on death to have their house bypass probate. The reason I want to mention these things is because you should probably have a will. It just lets people know where you want your stuff to go and who's going to be in charge of that process after you pass away. One of the things people don't realize is your executor in your will actually can't do anything for you until you have passed away. It's your power of attorney, your general durable power of attorney, that can help with things like paying bills or being able to work with your different financial or legal type decisions on your behalf. Someone that could do that during your lifetime if you need a little bit of help with those things at some point in time. And all of us could need some help with those kinds of things at some point in time, either because of aging or because of something that goes on with our health. Healthcare power of attorney is something everyone over 18 should have, because we could all be in a car accident, be unconscious for a short period of time, and need someone to tell healthcare providers what to do for us until we recover. So extremely important. The living will isn't for everyone. That's for lack of a better way of saying it, it's the pull the plug document. If you don't want extraordinary measures when you are in a permanent coma, or you have a terminal illness and there really isn't a cure or effective treatment available. And so it's important for us to make our wishes known in that regard so we can take that burden off family members. Okay, covered the documents other than the trust, and we'll circle back around to that. But what's really important is to know that most people want to avoid probate. I mentioned the length of time. The other reason, the cost. Oh my gosh, the cost of probate. On average, in the state of Ohio, according to AARP as well, the average cost is somewhere in the ballpark of 5 to 8% of the total of what someone has. Now, let's put that in perspective. If you have an estate worth $200,000 in total, and let's say that's 125,000 house or small condo and 75,000 in checking, savings, and a CD. So if that's going through probate, that's $200,000. It's not a ton of stuff, right? It doesn't sound overly complicated. If the cost to probate that ran in the ballpark of $10,000 on the low end up to $16,000 on the high end, would you find that shocking? I found that shocking, but if the cost of probate is averaging from 5 to 8%, that's what the cost would be. And the majority of that doesn't go to the court. It actually goes to the attorney. And so here I am from a law office with my attorneys knowing and wanting me to tell you all that you don't have to pay crazy probate fees, or at least your family doesn't have to lose that portion of what you'd be leaving them to that ridiculous cost if you plan to avoid it. And so a trust can help with that, but not everybody needs a trust. There are other ways to avoid probate. You can do payable on death, use beneficiaries, transfer on death. Those are things that we can help you out with, or you can find out through financial institutions and other means. But you can avoid probate without using a trust. Now, on the other hand, trusts can be really useful. They, by default, avoid probate. It's part of the main job of a trust is to basically put your own rule book in place to wipe out that massive delay that goes along with probate, but also to keep down the cost so that not so much money is wasted on that lengthy process. So one of the things you should all know is that while you probably should have a will to settle any disputes or disagreements, you probably don't want your stuff going through your will. So you can avoid probate by setting things up with payable on death, transfer on death, beneficiary designations, all that good stuff. Or you can use a trust. And we'll talk a little bit about what that means as well. So I mentioned the will names who gets your stuff and who's in charge, your executor. But the will goes through probate, which is slow and expensive. So probate is a legal process through the probate court system, average 8 to 12 months, all the controls with the court, not your family. The executor is the person whose job it is to be the intermediary between the court and the family members. Entirely public. You can find out what's going through probate and the cost, somewhere between 5 and 8%. This is, I mentioned that there were a couple of numbers that are a little outdated. This is one of them. We put this presentation together a few years ago. And so since then, the cost of things have increased as well as the cost of probate. So a trust is one of the alternatives. And so there are two primarily different types of trusts. The first one is a revocable living trust, and trust can sound complicated. And so let me clear that up before we get going too much further. A trust is just a different way to hold your stuff. That's it. Sounds a little more formalized than it is because you get a new title when you form a trust. And you can be in charge. You don't have to turn control over to someone else, but it allows you to put in place a contingency plan that says if there's a time you can't be in charge, here's who can. Well, this sounds pretty great, right? This way we're prepared in case something unexpected happens that could throw a wrinkle in things. So, like a health event or, passing unexpectedly, things of that nature. Or, maybe the health event isn't something catastrophic that happens all at once, like a massive stroke. Maybe the health event is a gradual decline. Maybe someone develops dementia and they're pretty good at managing things. Maybe they need a little help with that. So they can have someone co-manage that trust with them, or the person can be named to take over in their place if the individual trusts them in handling those things. A revocable living trust is simply a trust that you can put things in, take things out. You've got complete control. Everything in there is completely accessible to you. It avoids probate. Things go over to your beneficiaries. And it's even possible to have things go to your beneficiaries in a protected bubble so that what you're leaving to them can be protected from someone taking it away from them. And you can even do things like put in place speed bumps and guardrails, which some people need, right? If they're not yet mature enough to handle money and finances well. Or maybe maybe you're in your 60s or 70s and you've got adult children that you are having to help out financially when they overestimate their own, or they underestimate their own spending. And so you might have to, help them financially. This can be a safety net so that those kinds of abilities to help someone out if they get themselves into trouble is still there even after you've passed, by putting certain safeguards in place for what you are leaving them. And you can protect things in the event of a divorce, a bankruptcy, someone suing them, all kinds of things. And that can be for either the revocable living trust, which is the kind most people have, or the hybrid irrevocable trust, which is a type of trust that can help provide protections to you through the rest of your lifetime. Protections from things like lawsuits or a Medicaid spend down or lien. And we'll talk more about that as well. Those trusts, either type, completely avoid probate, getting rid of that massive delay. Those can be wrapped up much more quickly and at nowhere near the cost of going through probate in most cases. So, not knowing your predators. We threw this in here because, oh goodness, times are a changing, and it's hard to know who's making good decisions these days. And part of the time, and this isn't a political statement, sometimes the government's included in that, right? The way money gets spent, we may not agree with. And so it's also about, all of the different taxes that we pay. Our assets can be threatened by lawsuits. Everyone wants to hire an attorney these days to sue someone for something. I have to tell you, I met with someone earlier today, and in the course of a 40-minute conversation, he asked me if he could sue 4 different people. And we don't do lawsuits. We don't do litigation. That's not something we do at all. So I could refer him out to lawyers who do that. But oh my gosh, he doesn't even care what he sues someone for. That gentleman wants to sue someone. And unfortunately, there are people out there like that. So you can protect yourself from people like that by using certain types of trusts. As I mentioned, one of the ways is by using one of those hybrid irrevocable trusts. Our own family members, sometimes our family members, through no direct choice of their own, but by something bad happening to them, can be a threat to our assets. So most of us know the law changed regarding our cell phones and, texting and all that good stuff while you're driving. But how many of us have a relative who, still is probably going to text, talk with the phone in their hand, do different types of things that might not be all that safe? What if they're doing that in a vehicle that we own? We could lose our assets due to them causing an accident and there being a lawsuit, and the settlement of that lawsuit being greater than what our car insurance covers, which unfortunately does happen, and more often than most of us would be comfortable knowing. And then the last thing we have on here, nursing home costs. Not that nursing homes are out to get anyone. Goodness, no. They provide an incredibly vital service. The challenge is the cost of long-term care services has risen dramatically because so many people have left the caregiving industry over the last 3.5 years. And their costs have gone up for utilities, food, all of those things, and labor, just like we personally have seen all of those costs go up. So the amount that it costs to pay for long-term care services, specifically nursing home services, will just blow you away at this point. In Central Ohio, that cost is averaging between $10,000 and $12,000 a month. You may be able to find a few places that are under 10, but that's becoming more and more rare. And I just spoke with one of our clients who entered a care center paying $14,000 a month. So it's absolutely staggering because I don't know very many people that can cover those kinds of costs out of their income each month. So that means that money has to come from somewhere else. And unless you are very wealthy or you have really great long-term care insurance, most of that cost is going to have to come out of your savings. The other thing that we want to cover is taxes, gift tax, capital gains taxes. There's a significant amount that we can be liable for. Now, the gift tax thing, unless you have a ton of money, it's not the kind of thing that you pay a lot of taxes on when you gift something to someone. And there is an exemption. And this year, it's $17,000 per person. I mentioned a couple of these numbers. I didn't quite get updated before this presentation. But, if you are, some people are like, oh, I'm going to gift my home to my child. Well, that can be a double whammy. That could set you up for gift tax. It can also set them up for capital gains taxes. If they didn't purchase it, and if you've had it for quite a while, especially with how the real estate market has been, the value of your home could have risen dramatically. Your child didn't pay for it. They probably aren't going to be living there full time. And so if they turn around and sell that home down the road and you paid, a more modest amount for it years ago, they're going to have to pay capital gains taxes on it. And so that can be a huge issue. The other thing, it's not on here and it's not a tax, but what happens if, God forbid, your child that you transferred your home into their name, they lose their job and have to declare bankruptcy, or they end up in a divorce that they didn't see coming when you transferred that house into their name. So you could lose control of or outright lose what you've given to them. by making that gift. So we think gifting is something that people need to really think through very seriously and probably sit down with an attorney to discuss before they go ahead and do that, to make sure that they're looking at all of the possible things that could happen that they're just not anticipating yet. And sometimes we put on rose-colored glasses when it comes to thinking about our family members, but we've got to remember to look out for the things that do happen, unfortunately, to too many of us that we didn't expect to happen. When we talked about lawsuits, those can be business or personal lawsuits, can affect your home and property. Most of us, our car and the people who drive our car, if we have children driving vehicles, whether they're in high school, have graduated from high school, oftentimes it's still our vehicle that they're driving and, our insurance. So my goodness, if something happens, that's our liability. And so that could really threaten your assets during your lifetime. Could also threaten your beneficiaries' assets during their lifetime. And as I mentioned, there's a way to put those assets in a protected bubble so they can't be lost when they're inherited by their children. And also a way using that type of hybrid irrevocable trust to protect your assets through the remainder of your lifetime. And so, not knowing your predators, family members, it's not that our family members are out to get us. It's not like that at all. But lots of complications happen, especially in blended families. I'm part of a blended family. We have 5 kids between us. I have 2, he has 3. We've been together for 20 years. We still have some sticky situations that, we have to figure out how we're going to handle. And now we have grandchildren. And so lots of things coming on. What happens if I pass first? And, I want certain securities for my kids and my grandchild. And so being able to put things in writing that we both agree upon and that will be carried out regardless of which one of us passes first. I'm not intending to disinherit his kids if, God forbid, he would pass first. But what if I would get remarried? What if I pass away before my new spouse? Do I trust someone else to honor both my children and my current spouse's children? I don't know. That's a lot of trust. And so it would take a really special person to do the right thing for both of us and our kids and grandchildren. I'm not sure that that's something that we would be comfortable leaving to trust. And it is something we've put in place to cover by doing, actually, we did separate trusts to address that. Family's bad luck, disability, someone needing the nursing home or needing Social Security disability, and the asset rules that come along with Social Security disability, or going into a nursing home if someone needs to access Medicaid at some point in time. And then we mentioned lawsuits and divorce. Also, I've got 2 kids and I use this example all the time. I've got 2 daughters. They're amazing and wonderful, but they couldn't be more different than each other. My older daughter, who's the most loving person you'd ever want to meet, would give you the shirt off her back. But sometimes that's the problem. She's too giving. She doesn't save for herself the same way that my younger daughter does. And so she would, at her own expense, give away everything that she has. And she might overspend too. And she just isn't quite as good as planner as my younger daughter. And so in my trust, I've put some provisions in there about they can get out of the trust after I've passed away so much per year. And so that way, I know that there's always going to be a safety net, and that they won't create a situation where they have really big regrets because they did something very spontaneous. Like, gosh, I don't know how much I'm going to be leaving, but they could probably buy a decent car, but they might not need a shiny new car. Maybe it would be better left in savings for our grandson's college or something like that. So by me putting those speed bumps in place there, it's going to last longer. And there's some wording in there that if something important happens, then they need to get more of it and it's outside of their control, then they can. But as a general rule, only so much will go out each and every year. And then, one of our clients, I think this is brilliant. One of our clients put in his trust that for his grandchildren, who, it's 2 generations apart, right? From the grandparent to the grandchildren. And he is just really cognizant of the fact that when he was raised, his parents talked to him about the difference between wanting something and needing something. And you spend time thinking about that difference. And the purchasing decision is made on what you need. That's how he was raised. Well, he's watching his grandchildren who are teenagers, and, they have part-time jobs, but they also get an allowance from their parents. And so they're shopping on their phones and they buy whatever they want. And heck, half the time it shows up on their doorstep the same afternoon from when they bought it. And he can't figure out why they buy half the things they do because they don't need them. They want them. And so it's a generational difference. So part of what he's doing is he's passing on values, which he thinks are important. And so he's written into his planning that they can each receive. And so he's put a small amount aside for his grandchildren. They can each receive in a given month, once they get to a certain age, as much as they earned, but no more than that. So he's trying to set a solid set of values for them around work and earning, and trying to get them think more in the perspective of you spend what you've earned. And you think hard about that so that you get a good value for your money. But I just think that the way he set that up is just, something that some people really notice in the difference between how we were raised, the value of a dollar, thinking about that, versus how some younger individuals are raised. And part of that's around technology. And boy, how that has all changed, right? So I mentioned nursing homes and the cost of care. And in this slide, it says 6,000 to 12,000. As I mentioned, this presentation is a couple of years old. And so in Central Ohio, the average cost is going somewhere between 10 to 12,000 per month. There are a few care centers that are still under 10. But as I mentioned, have recently had a couple of families paying $13,000 and $14,000 per month for one person in the nursing home. How long would your savings last in that situation? And, I went through this with a grandmother who had a series of strokes. She had the first stroke and my mom and dad moved her into our home. She lived there with us for about 3.5 years. Then she had a massive stroke and couldn't walk. She was entirely bedridden. She needed 2 people to help her with pretty much everything. Well, we didn't have 2 people who could stop working, who could literally quit their jobs to be full-time caregivers. And so my mom happened to be a social worker in a nursing home, so she took her to the nursing home where she worked. Well, she lived for 4 more years. She ended up spending through her life savings, and she also ended up losing her home to that cost. She was heartbroken by that because she and my grandfather had worked so hard. And the reason they had worked so hard, they had started out with very modest beginnings. Neither had gone through college. And, it was their dreams to have their kids not only go to college, but for them to be able to leave them a little bit because they started with nothing. They didn't receive anything from their parents. And, as very proud individuals, they wanted to be able to give the next generation a better start. My grandfather had already passed when all this happened to my grandmother, and she died penniless. And it was incredibly, I'm sorry, I'm going to get choked up because it still bothers me. I still remember her being so emotional about this. But it robbed her of her personal dignity. And that is why I feel so strongly about what we do. So there are options to the nursing home. You can stay home with home care services. It's also very expensive at this point. There's independent living, assisted living, and of course the nursing home. And so with how to pay for care, you pay like my grandmother did. You exhaust your savings until you've got, according to Medicaid, less than $2,000 left. That's pretty much broke. If you've had to spend through everything that you've accumulated. If you're single, that includes selling your house and liquidating the proceeds from your home. If you're a married person, they won't make you sell the home out from under your spouse, but they're going to come back and put a lien on it for whatever they end up paying for on your behalf. So you either pay out of your savings, you have long-term care insurance that will cover the full bill along with your income. I don't know many people that have long-term care insurance that will cover that anymore. As I mentioned, the cost has gone up significantly, and the cost of long-term care insurance itself has gone up. Most people have, in order to keep the cost of those premiums from going up each year, most people that I speak with have locked in their premiums, which also means they capped the amount their long-term care insurance will pay. And as the cost keeps going up for long-term care, the long-term care insurance isn't really doing the job it used to be able to do. And so more and more people are having to look at, even with long-term care insurance, still pulling a significant amount from their savings, possibly still exhausting it. And the last item here, the government pays. Well, what does that mean? It's Medicaid. So most people over 65 have Medicare, which is health insurance. Medicaid is a type of healthcare coverage in the long-term care setting that will come in when the person has spent down. So for a single person, spend your assets down until you have less than $2,000 in your name. If you're married, they're a little more generous. We'll go through a couple of examples, but you'll see how this works out. Not so great. But so the government doesn't contribute until you've exhausted your assets. And it also sometimes affects income for the spouse who's still living in the home. Not that they take their income, but they have less income to work with for the household bills. And then they want to put a lien on the house in the end to pay themselves back anyway. It's just absolutely mind-boggling that we save and we put away for a rainy day, and then it can all get wiped out because something happens to our health. So as you can tell, the experience my grandmother went through has really affected me. And it's something I feel very passionate about, helping families prevent from happening. And you can. We're going to talk about that in a few minutes. You don't have to go broke. You don't have to lose everything. You don't have to impoverish your spouse. And you can still maintain your dignity. We didn't know that when my grandmother was going through this. And so It's one of the reasons I can't imagine working anywhere else or doing anything else, because it just is one of my greatest joys to help families protect themselves and to be able to ensure that they maintain their dignity and no one can take away from them what they've worked their lifetimes for. So if your health fails, there is more than just Medicaid. You can get care at home, also assisted by the government. There's if someone has been a veteran during wartime, they may qualify for a program under the VA health systems umbrella that can help pay for things like care in the home, assisted living, or even help with part of the bill for the nursing home. This isn't someone who, was injured in the service. It's just veterans who have served during wartime for a period of 90 days or longer. And so it is something, our attorneys are certified under this program and can help you figure out if it is something that you qualify for. It's never going to pay the whole bill, but for a veteran, it's a little less than $2,000 a month. If they're married, it's a little more than $2,000 a month. And there's even a benefit if the veteran has passed away and their spouse or widow also needs help with those things and is incurring a cost. They'll kick in a little more. The amount they cover for a surviving spouse is more modest, but it's still a help, right? And so it's extra money that doesn't come out of your savings or may make the difference between someone being able to have some extra care or not being able to afford that. Again, there's Medicaid. There is a program that can send caregivers into the home so you can stay home longer. Who wants to leave their home for care, right? None of us are sitting here going, oh, I want to go to the nursing home. Sometimes there's no choice. And so if you go to the nursing home, people aren't, there because they were the first ones in line to get through the door. Something happened to their health and they didn't have the support system that could care for them day in and day out, 24 hours a day, 7 days a week, 365 days a year, year after year. I can tell you my parents were doing it part-time before my grandmother had that massive stroke. And we had an aunt and uncle and cousins helping. The whole family was involved. It was still exhausting. I know there are caregivers who do it, just the one caregiver. And most of those people, it's amazing that they do what they do, but it takes a toll on their health and usually on the relationship. And so it's something that, doesn't have to happen. You can get extra help through some of these programs. Challenge is you still have to go through that Medicaid spend down, and they still want to slap a lien on your home if you own a home. In the nursing home, Medicaid and the veterans benefits, the same thing. You have to qualify financially as well as from a medical need standpoint. And it's a heavy toll to go through that spend down or to let them come back and put a lien on the house. You can prevent those things from happening, but let's look at what it looks like. So initially, there are certain exempt assets. If you're a single person, those include your car, a prepaid funeral plan, and the stuff in your house. They're going to say, don't worry about those things. We're not going to count them. They're going to count everything else. Cash value of life insurance, your home, any financial accounts you have. They're going to add all that up and they're going to say, sell it all, spend it down until you've got less than $2,000. Again, I just no respect for how hard someone has worked over their lifetime. And so, the way that works, what that looks like, let's say for John, the value of his assets was $100,000. he would have to spend down 98,000 until he has less than 2,000 left in his name. So that is really sad. And in John's example, if he put his house into a trust and we get it in there before the 5-year look back, we can protect the whole thing. So we've got the 5-year look back with Medicaid. Someone applies for Medicaid, they look back 5 years to see if you've changed how you hold your assets. And so in John's case, we could save the entire 100,000 if he had planned ahead. Even if John's going into the nursing home today and he has that 100,000, usually the worst we can do is save half of it, even if he needs care today. And that's something some people don't realize, that there is a 5-year look back, but you don't always have to make it through the whole 5-year look back the way Medicaid's rules work. We can usually protect a portion. In most cases, it's at least half of what someone has, even if they can't get through any of the 5-year look back. Oftentimes, the more time you give us, the more that can be protected. And so it's something that can happen. One of the primary ways to do that is by using that special type of hybrid irrevocable trust, because it's a way that Medicaid recognizes that lets you take that asset off the table. And so I see in the comments that we have someone from Job and Family Services who's actually watching the webinar, and they're saying, yeah, that's absolutely right. They've seen this happen often, and planning ahead is one of the best things that you can do. And from my personal experience, I see it every day. And sometimes you have time, other times you don't. If you can plan ahead, you'll get a more positive result. And if something does happen, it's not the end of the world. You still don't have to lose everything. When this type of planning occurs, we work with Medicaid's rules and we follow their rules in order to protect things. So when someone has less than 5 years, usually they're still spending some, but not necessarily exhausting everything that they've worked for. And the next example we have is for a married couple. And if they had $100,000 in assets, this is in addition to their home. As I mentioned, they're never going to make the person who's living in the home, they're never going to make the house be sold out from under them. So Medicaid's rule is when the assets are a little more modest, they do a 50-50 split. Person who's at home and healthy, they get half. The person who needs the care, they're assigned the other half. They have to spend their half down until they have less than 2,000 in their name. So in this example, it would be spending down 48,000. That's Medicaid's Plan A. That can be changed. And so when it's a married couple, there are different ways to do that. Sometimes it's that trust. Sometimes there are some other tools that can be used. And so it just what makes sense for that family and what the time frame is. But again, that entire amount can be protected and the lien be prevented from being placed on their home. This is another example. And again, I apologize. These numbers are a little bit different at this point. They're about 20,000 different from when this slide was prepared. And again, I apologize. I didn't have a chance to get this particular presentation updated. I pulled it out of the cobwebs, but it was nice and short and sweet. So I thought it would apply well to this evening. So this is a husband and wife. They've got their home plus $400,000. They don't get a 50-50 split. As I mentioned, when the finances are over, and in this case, it's over just a little less than 300,000, it's no longer a 50-50 split. The at-home spouse in today's numbers would get to keep 148,000, The 252,000 would be assigned to the healthy spouse. Or I'm sorry, the spouse needing care, and they would have to spend that down until they had less than 2,000 in their name. So a spend down of 250,000. That's huge. It takes so long to earn that. And so again, we can protect that. We try to get as much time under our belt using that 5-year look back. If we can get through 5 full years, we can protect everything. But again, in most cases, any amount of time we can get through that look back usually allows us to protect more. And again, the worst we could do in a situation like this is protect half of the 200 plus thousand that would otherwise have to be spent down. So there is so much that can be done. And again, it comes down to the right types of legal tools. And again, everything that we do is completely within the rules of Medicaid and the IRS. So we're just working with their rule book, similar to the way an accountant helps take advantage of all of the credits and deductions that help us save more on our taxes. That's similar to what an elder law attorney can do when it comes to Medicaid. So I did want to let you know, and again, I'm happy to answer any questions that you've seen or you have. We do offer at our office, if you have questions, we offer a no cost consultation so that you can find out what can be done and how long would it take, what would be involved in that. And you can find that out with no out-of-pocket expense so that you know what choices you have available and you'll know what it would look like if you wanted to pursue making any of those choices. Our process is a little bit different. The first meeting is with a non-attorney, someone like me, who has been working with individuals in planning for long-term care and in trying to avoid extra costs and delays, and really to not put a burden on the family later on, not leave a big mess, as many people put it, and get everything wrapped up nice and neat and make it smooth and easy, whether that's a health issue down the road or when we do eventually pass away. So trusts are very good tools. They can serve a specific purpose. But again, not everyone needs a trust. I myself have one because I saw what my grandmother went through. Both of my parents, they had a trust. And so my dad passed away recently of a stroke, and my mom has Alzheimer's. And so we're caring for her. She's living with my older sister right now. And maybe we'll be able to keep her home with them until she passes. But if not, she'll be able to go to a care center, and it won't be a repeat of what happened with our grandmother, which is so important to my mom. She felt very responsible for my grandmother losing everything because she couldn't quit her job and be that solo caregiver. So anyway, not going to burden you with my story, but what questions do you have? I'd be happy to answer whatever I can.
I see one on here. It says, "Thank you for sharing your story. If you put your house in a trust, can you avoid having a lien put on your assets since it's in a different entity name?"
So most of the time, yes. And what has to happen is it would need to go into the trust before whatever it is happened. So let's say you put it into the trust, you need long-term care. Yes, they won't be able to come back and put a lien on it. But if you haven't made it all the way through the 5-year look back, there could be an amount that's due to the nursing home or to Medicaid. Because when you don't make it all the way through the 5-year look back, there's a consequence or a penalty, a period of time Medicaid won't pay, which is why we can at least protect half, but the other half may have to go towards that. Depends how far someone's gotten through that 5-year look back period. It's important to talk to an attorney about that. It's not all or nothing, but Medicaid's calculations are very complex. And so the attorney who's very familiar with that can figure that out pretty much down to the dollar, how much can be saved. If you get through the full 5-year look back period, that's an easy one. It's all protected, whatever was in that trust. And so fantastic tool for that purpose. The other thing is with a lawsuit. Let's say you put your house in the trust and, $100,000. But let's say you keep, 50,000 outside of the trust and you get sued because you caused a car accident. And the stuff in the trust is protected, but you could get sued for what's outside the trust. You could lose that. Now, what happens if you cause the car accident and then you want to try to protect your stuff after the car accident? Doesn't matter. You can't do it. Trying to take those things outside of your assets after that event has happened, it's too late. And so that's why planning ahead and being prepared is so important, not just for Medicaid or the nursing home, but even just personal risks.
You see a lot of people taking their businesses and putting their businesses under trust. Is that, how are the dynamics with that?
Absolutely. And so we have quite a few business owners who do this. Sometimes it's people who own rental properties. Other times it may be a doctor or another professional that experiences a lot of liability type issues because of their type of work. And so it is a way for them to help protect what they have from losing what they've been working their whole career towards. Now, when our attorneys sit down with them, they also talk to them about, responsibility and having professional liability insurance, umbrella coverage to take care of things in the event something like that does happen. But they don't want to risk everything they've worked for in case there is some crazy jury verdict. In Ohio, we don't usually have jury verdicts for tens of millions of dollars or hundreds of millions of dollars like you still hear about in other states. But it's, things still do happen. We had someone come to us, it's probably been 5 or 6 years ago. They had transferred their house into their son's name, and their son, he was rushing to get to work, caused a car accident. He injured a single mother. Sole provider, 2 young children. She was unable to return to work because of her injuries. They came to us because they wanted to protect the parents' house. Like, the son was just like, fine, take everything. He was just devastated by, the impact of the accident on her. He would have given up everything, but he didn't want his parents to lose their home. Well, they had put it in his name to try to protect it from the nursing home. Well, they didn't know he was going to cause a car accident. And so they ended up losing their home because we couldn't put it into the trust after the accident.
Wow. That's bad. That's bad.
Very sad. It was just a really sad situation the whole way around.
Well, I was looking to see if anybody else had any other questions. No one's put it in yet.
So one of the things I often am asked is, why would someone do a revocable trust versus a hybrid irrevocable trust? If you can, get all that protection from the hybrid irrevocable trust. And we call it an asset protection trust because that's its job, protecting someone's assets. And sometimes people just aren't ready yet for the hybrid irrevocable trust. So there are some extra rules that come along with that protection. So the attorney will talk to the person about what that looks like. Again, everything in there is protected, but the individual still has control over it. And there are different things that you do have to plan for. You've got to be even more careful about who you choose as your backup. But just wonderful things there. But people who have amazing long-term care insurance and who are 100% sure they're going to keep that in place, or who are younger in life, maybe parents with younger kids. They don't need that extra protection yet, maybe unless they are a doctor or someone or a business owner. And so they don't need the hybrid trust or the asset protection trust quite yet. The revocable living trust may be perfectly fine for their purposes at that point in time. And the way our firm handles that is if you want to convert from one to another, you can't change the trust, but our firm will honor the cost for what you did for the first part of your planning and basically credit that towards converting it over to the protection trust at a later time if you want to do that. We have had families do that.
Like, so I'm coming in, I'm really oblivious to the whole trust thing, but I want to put a trust together. What are kind of the steps to get started?
So as I mentioned, with the first appointment is with a non-attorney in our office. We call that individual a client navigator. And their role is to ask a bunch of questions to figure out what the family dynamics are, what are the assets involved, what's the plan for, remainder of working years, or the individual's already retired, and understand, is there long-term care insurance? What does their health look like, as well as family history, so that when the individual sits down with the attorney at the next appointment, the attorney is able to say, okay, here are what your options are based on all of these factors. And so here's what we're recommending. The attorney will go through explaining that, review any pros or cons, and then give the individual the complete cost for whatever it is that they want to do down to the penny. We don't do hourly billing, we do flat fee billing. And so it's based on the amount of work that we do. And we've been doing this, as I mentioned, for about 20 years. So we know how long it takes to do these things. So the attorney can do that. And then he can say, and here's this other option, and we can accomplish something similar, but maybe this doesn't do this. You mentioned that you'd like to do this, but you didn't say it was the most important thing. So the attorney can kind of walk through that and help them make the choice that's right for them, knowing everything that's involved in the planning.
Okay.
And if someone doesn't need a trust, we'll tell them, you don't need a trust. You can accomplish these things in this way. And we're happy to do that. And we have a little guide that we give to all of our clients who want to do that without a trust, how to avoid probate, walk through how they do that with them so that they're armed with that information and they can avoid probate and they don't have to use a trust. So it just comes down to what's important to that individual, and it's different for everyone.
In regards to a will, so in creating a will, are there really like legal templates somewhere, or is it important for you to maybe consult an attorney first, or vice versa?
So we think it's important to have a conversation. Now, we have a DIY platform that we've created as well. So that's something that we can give people access to. Templates, whether it's from LegalZoom or Susie Orman, or so many of the different options are out there. It's important that what someone uses is specific to Ohio. And it's important that the individual know what it's going to do that they're putting in place and what limitations are built into it. So the financial or general durable power of attorney, that's actually one of the most important documents any of us could have. The statutory or default general durable power of attorney in Ohio actually has a whole bunch of handcuffs built into it, because that document is put together for anyone to use from the age of 18 to over 100. Now, if you're a 45-year-old and you've got a couple of kids, do you want to give them the ability to do anything and everything with your assets?
No.
My kids are in their 30s now. There is no chance I would have given them that kind of power, because, oh my God, at that age, no way. And so that's kind of the way that document is built, assuming that the person that you're going to give that authority to maybe doesn't really deserve your full trust, or they need limitations kind of built in there. The challenge is, if we're trying to protect assets later on in someone's life, we can't have those limitations, because that document, the default document, limits the person to protecting about $17,000 per year. It's tied to the federal estate tax limit, that annual gifting limit. Well, that's going to get you absolutely nowhere in protecting your assets, right? That's not strong enough. It also doesn't let them do a lot of different things. Apply for Medicaid has to be written in there. You know, being able to put a trust in place if they didn't do it for themselves, if that's the right tool, or using certain other tools. So that power of attorney document, it's why it is so important they sit down with someone and talk through that. The other thing is, well, what if it's, it is a 30-something, 40-something-year-old, and they have children under the age of 18, and they want to make sure that their kids go directly to the person they want them to, whether that's a family member or a friend, and not into the custody of Child Protective Services. Not that they aren't going to do a great job, but they don't know them, right? That if, something has happened to the parent, those kids are already going to be devastated. We want them with someone they know, and they know is, going to be able to take care of them. Well, there are things that you can put in place ahead of time to stipulate those kinds of things, so that you're naming who that guardian will be, both on a temporary basis as well as who you're nominating for permanent guardianship. And then putting the documents in place that gives them the authority to make medical decisions for the minors, right? Because they don't automatically have that. So that's why I am very hesitant to recommend those platforms, because they're not going to talk through all of these different things and tell you what's not in there and what you should be thinking about. And the other part I mentioned with my girls, I've got 2 girls. I love them both. I really do. My oldest daughter, so sweet, so loving. She is not good with money, and she is my drama queen. So when I need a cool-headed decision maker, that's actually my younger daughter. She's black and white, analytical. She's going to weigh all the pros and cons. She's going to get more information from this person and that person. So it's a conversation that needs to be had. I tell you, we sit down with families and I'll ask them who they're thinking about for certain types of roles. And they're like, well, my oldest son is, and I'm like, is he good with money? And they're like, no. And I'm like, okay, you want to put him in charge of your money? Oh, yeah, probably not. But it's like people aren't thinking of that. And that's the part that makes me nervous about the forms. You need someone to walk you through those decisions.
Yeah, definitely. Definitely. Well, I don't see any more questions, but I want to say that I appreciate all the information that you've given. It's been a wealth of knowledge once again. And also, if we could somehow, I could give me your information so that way I can put it into the chat and stuff. So then that way, people that are actually watching it even beyond today, if they want to get a hold of you in the office, add
Absolutely.
that in there as well.
So I'm going to put the phone number in, which is, and I don't know if this is going into the live chat, Barbara.
I'll put it over there.
And I'll put the website in as well. But it's 1-877-653-3450. And the website is jarvisfirm.com. And so we've got an answering service for after hours, but we have ladies on our team during the regular workday who are just also very easy to talk to and a wealth of knowledge. And if someone does have questions or is just curious, feel free to call. They're there to share information and to try to help you figure out whatever the right path for you is.
Appreciate it. Thank you so much.
Thank you again,
Stay
Barbara.
with me and we'll log out of this. Thank you, everybody, for tuning in tonight. And I just hope that you were more educated in the area of wills, trust, all of the kit caboodle that she talked about, the nursing home cost, all of that. And if you need to, watch it again. It's available for you anytime you need it. Thanks so much, everyone, and you have a great evening.